my name is Amir, and I'm from Group 12 of Constitutional and Administrative Law 2 for the April 2020 semester. My group and I will be presenting regarding the various administrative theories and which one would be applicable in these current times. Before we begin, I'd like to introduce my other group members. Firstly, we have Audrey Ng. Then we have Lim Yixuan, Calvin, and last but not least, Cherry. Now, with that out of the way, let's begin with our video presentation. Administrative law is a subset of constitutional law which is concerned with the establishment, duties, rules, and powers of the executive. It functions through the process of judicial review. Through judicial review, key constitutional concepts such as rule of law and separation of powers can be upheld. In light of recent events in 2020, particularly the COVID-19 pandemic, questions have arisen regarding the role the court should adopt in reviewing cases in the midst of these trying times. Hence, this video aims to determine the most suitable theory to be used in these current times. Before we look at the various administrative theories, it is important to look at the key constitutional concepts in the UK that relate to them. For this, I'd like to invite my fellow groupmate and friend Lim Yixuan to explain.
Hi, I'm Yixuan, and I'm going to talk about constitutional concepts in relation to traffic light and right-based theories. Central to the red light theory is the idea of rule of law, which provides the basic idea of limited government and constitutionalism. As described by Dicey, this theory looks into the model of balanced constitution, holding judicial control of executive power. However, as executive gains power to formulate government policy, and the parliament is dominated by the government of the day, Lord Haishan coined the term elective dictatorship, where the executive is unwilling to respect the independence of judiciary. On the other hand, the green light theory minimized the power of judiciary, upholding the supremacy of parliament. This theory accommodates a broader concept of social welfare. Therefore, the executive should hold wider power, which should not be limited by the wish of judiciary. The right-based approach leaves much to judicial discretion, and therefore threaten the principle of separation of power. Without a Bill of Rights making individual right legally enforceable, the adoption of right-based approach could significantly limit judicial review.
Thank you, Li Xuan, for your explanation on the concepts of the UK's constitution. I will now be explaining the concept of red light theory in relation to constitutional and administrative law. The red light theory represents the nature and purpose of administrative law that controls state activities in order to regulate state operations for the safety of its individuals. Now, as briefly mentioned by Yixuan, this theory can be connected to A.V. Dicey, who theorized that different rules formed from the court rulings for the protection of its individuals have placed the court at the core of the Constitution, and exposing general political principles of the judicial review. The judgment in the case of Annie-Smith was an example of this theory in practice. Now, red light supporters take the view that 1. This law is superior to politics, and 2. That the administrative process must be kept under control. And as such, the nice way to accomplish that is through the total rule-based proceeding within the courts. They also believe that the public law's main objective would be to improve the liberty of an individual. Now, this particular stance is supported by Friedrich Hayek, an economist and a political theorist who believed that there was a close link between the rule of law and a limited state. In his book titled The Road to Serfdom, he established a difference about the rule of law and an arbitrary government. It is seen that Hayek assumes that individual freedom as consistent with the equality of others representing the concept of a liberal democratic culture that requires independence from the state, and further, demanding that certain individual freedoms or rights be secured from decisions by the state and the majority, is the norm in a state which practices rule of law. Hence, this theory aims to regulate the action of the state in order to protect its citizens. And now, I shall pass it on to my group mate as well as friend, Kelvin, to continue this discussion.
Thanks, Audrey. Now I will be talking about the green light theory. The green light theory is a branch of administrative law where the United Kingdom theory fulfills some policy objective. This idea is mostly used in the course of the interwar duration or emergency time. It promotes productivity in the governance and policy-making process. This policy-making system prevents the interference of the court with its obligations assigned through statutes or acts. Green light theories claim that the law is a complex political debate and is neither separate from politics nor superior to administration. Secondly, they hold an opinion that public administration is a quality to be welcomed instead of a tolerable evil. The function of administrative law is thus not only about avoiding poor administrative practices, but about promoting and supporting good administrative practices. The intention of this plan should be to enhance individual and collective liberty, where liberty is assured of as something which is at least primarily driven by it, if not constituted by the state, and is certainly not inherently threatened by it. Moreover, the trouble of deference is one of substantial challenges in administrative law, which gain from greater interest to reference. For many, if no longer all, administrative law systems, the attempt to relax the tensions between judicial oversight, administrative discretion, and legislative delegation is a continuing situation. Now I will be passing to Wong Jiahui to continue our presentation.
So now I'm going to talk about some cases related to the green light theory. The Canadian Standard of Review Analysis, established in the case of Canadian Union of Public Employees, Local 963, and New Brunswick Liquor Corporation, and most recently refined in the case of Dunsmuir and New Brunswick, which allows the court to apply different level of deference depending on the nature of the decision being reviewed. Court will review administrative decision on either a correctness standard, which afford no deference, or a reasonableness standard. Later is the essence intended to give effect to the concept of deference and respect legislative choices to leave some matters in the hand of administrative decision makers, while maintaining the different role of the courts and administrative body within the Canadian constitutional system. In determining which standard to apply, Canadian courts apply a standard of review, which was formerly known as pragmatic and functional analysis, which asks which standard the legislature intended to apply by considering, firstly, the term of the statute, and particularly whether there is privative or ouster clause. Secondly, the expertise of the administrative decision makers. Thirdly, the purposes of the legislation as a whole. And lastly, the nature of the problem, whether the impugned aspect of the decision was more a question of law or fact. Also, in the case of Philip Morris Holland Bevy and Commission, the European Commission found that the aid given to the tobacco manufacturer did not fall within the exception of the relevant treaty, and the Dutch government challenged that decision. The Dutch government argued, among other things, that the Commission was wrong in finding that the standard of living in the area was not abnormally low and that there was not serious underemployment. In rejecting the argument, the European Court Justice held that the Commission had provided good reasons for assessing the lawfulness of the aid based on the European average rather than the Dutch national averages. It found that the Commission was entitled to exercise discretion in deciding this jurisdictional question. That's all for the example of cases regarding to the green light theory. Now I'm going to talk about the right-based approach. The right-based approach focuses on human dignity, which stated that our freedom is dependent on our ability to freely choose the way we live our life, and that we have a moral right to value our choices as a free, fair, and reasonable individuals, and a moral obligation to honor others in the same way. The main features of right-based approach can be laid down in the following proposition. First, the right should be individual right. The bearers of the right should only be individuals, since the aim of right access is to protect individuals against someone who has acted ultra vires. Second, the fundamental right must form part of a species of higher order law. These rights, which are held by individuals, could be able to prevent the government or society from doing something that is out of the society's general interest. Third, the primary aim is to perform right-based justice, which is to justify the right of individuals against those who are holding public power and threaten to infringe them. In the case of RN Ministry of Defense ex parte Smith, it concerned a challenge on a decision of the Ministry of Defense, which was said to have violated Article 8 of ECHR. The applicant argued that the anxious scrutiny should be applied, while the ministry argued that the so-called supervenire principle should be applied. In responding to this argument, the court thoroughly looked at the fundamental right dimension of this case. However, by concluding what Lord Justice said, the main issue in this case was whether the court had the requisite authority to declare the interference with the right of applicants to be illegal. The main factor in deciding the court's answer to this question was not right, but what was considered constitutional balance by Lord Justice Simon Brown. In the first instance, the challenge was filed, but the ban of homosexual was lifted in January 2000, and the appellant's challenge was successful. This is the end of the right-based approach. Now I will pass on the time to Amir.
Thank you, Cherry. Now that we have taken a look at all the relevant theories, the question remains as to what theory the UK should apply in the present circumstance. The starting point for this discussion would be to consider what the UK has done in the past. The case of Liversidge and Anderson illustrates that the courts are reluctant to interfere with discretionary power in times of emergency. Liversidge and Anderson concerned the decision of the Home Secretary, Mr. Anderson, to detain Mr. Liversidge. Under the Defence General Regulation of 1939, he was permitted to do so if he had reasonable cause to believe he had hostile associations. He detained Mr. Liversidge, but did not provide any reasons for doing so. The courts did not compel Mr. Anderson to provide reasons, ruling that as long as he acted in good faith, he did not need to disclose the reasons for detaining Mr. Liversidge. It is important to note that this case was decided in the midst of World War II, a time of emergency. Thus, the courts did not want to interfere with executive decisions relating to said emergency. Similarly, in Ex parte Hosenball, the court showed their hands-off approach in relation to matters concerning national security. Ex parte Hosenball was a case regarding the decision to deport Mr. Hosenball, a journalist who took part in an article monitoring communications by the government. He brought an action seeking the particulars of the decision. the courts denied his claim, despite the fact that doing so did not coincide with the rules of natural justice. Among the grounds for denial was that in issues concerning national security, the rules of natural justice were liable to be modified. In this case, the courts decided that the public interest requirement that such information be kept confidential actually outweighed the public interest in administration of justice. Thus, they denied his claim. These two cases clearly illustrate that the English courts give rise to the green light theory in such circumstances. However, the question remains whether spread of infectious diseases, such as is currently happening, would yield a similar outcome. The case of Queen and Davy is submitted as an answer to this question. In this case, the courts were willing to modify the rules of natural justice in not allowing the right to make representations to a mother whose daughter had been ordered to be removed to a local hospital. The reason for this action was that the daughter had scarlet fever. From this, it can be seen that the courts regard the spread of infectious diseases as similar to issues of emergency and national security, thereby applying the green light theory. As a group, we believe that the theory is the correct one to be applied in the current circumstance. However, its application presents a distinct problem. To further this discussion, I'd like to invite my friend, Audrey.
Thank you, Amir. Now, a potential challenge in implementing the green light theory would be the clashing of proportionality with the green light theory, at least in terms of judicial review. This is because the role of the judiciary may interfere with the executive. And this potential for judicial encroachment was recognized in the case of R against Secretary of State for the Home Department ex parte Bryan, where the House of Lords dismissed proportionality as the head of judicial review. In this case, Lord Roscoe stated that proportionality would push the court into substituting its own judgment of what was needed to achieve an objective for the judgment of the Secretary of State, upon whom that duty has been laid by Parliament. He found that the use of proportionality was impeding the power of the executives. He further concurs that by doing so, judicial review would be used as a tool to appeal against a decision instead of determining the credibility of the decision. And this was never the purpose of judicial review, and that granting such an extended authority was beyond the jurisdiction of the courts. This observation was supported by Lord Lowry, who agreed and stated that there can be very little room for judges to operate the proportionality doctrine in the space which is left between conventional judicial review and the forbidden appellate jurisdiction. And thus, it can be seen that the adoption of proportionality in the aspect of judicial review will raise the amount of applicants for said judicial review, with significant cost increase and lengthier court time due to the court's inexperience of balancing factors in the administrative decision. This is all from me. And now I would like to once again pass you to Kelvin to further this discussion.
Thanks again, Audrey. Now I will be discussing on a country that has done good in light of COVID-19. The government of Malaysia has come out with several steps and implemented actions to contain the COVID-19 outbreak. However, attention has been brought to the fact that COVID-19 does not fall under the Prevention and Control of Infectious Diseases Act 1988. Under the Part 2 of the first schedule of the said Act, although COVID-19 is not listed therein, the government claims that it could fall under the category of any other life-threatening microbial infection. Hence, the government could have relied on the said Act. Professor Gurdeep Singh Nijjhal, a senior lawyer, and Professor Shah Salim Farooqi, a constitutional law expert, both pointed out that including COVID-19 in the said Act is necessary, as this will qualify it as an infectious disease within the Act. Some countries, including Singapore and United Kingdom, have already listed the virus specifically in their version of Act. But Malaysia has yet to do the same. This constitutes a loophole where people cannot be charged under the Prevention and Control of Infectious Diseases Act 1988 for floating the Movement Control Order, which constitutes a measure under the 2020 regulations as COVID-19 is not specifically listed. The government has also come out with a subsidiary legislation, namely the Prevention and Control of Infectious Diseases Declarations of Local Infected Areas Order 2020. Nevertheless, Section 23, Subsection 1 of the Interpretation Acts 1948 and 1967 state that any subsidiary legislation inconsistent with an Act of Parliament or state enactment shall be void to the extent of the inconsistency. However, the instruction to employers to refrain from cutting wages or allowances is based on a piece of subsidiary legislation. Question arises on whether a piece of subsidiary legislation can override the primary laws, which are the Contracts Act 1950 and the Employment Act 1955. Although there are issues regarding to the policies of the government, no action has been brought to the court, and the court did not interfere with the decision made by the government. This clearly shows that green light theory has applied in Malaysia during this pandemic period. As a result, Malaysia has been ranked the best fourth country in a global survey on public approval of the government's response to the government pandemic. And now Yi-Xuan will continue the presentation.
In the current COVID-19 pandemic, over 100 countries have been put down in full or partial lockdown. However, as lockdown has disrupted many aspects of our life, anti-lockdown protests have erupted across the US. Signs like "Poverty kills," "Freedom over fear," "Don't let your mask be your muzzle," and "My body, my choice" has been displayed by the protesters. A music DJ recently posted on Twitter stated that, honest question, why do you think the United States is the only country on earth that's protesting against the lockdown? Another user replied, because people who had never truly been oppressed are being inconvenienced for the first time of their life and don't understand what it means to sacrifice in the name of greater good. In the US, the courts adopt right-based approach, which stretches on civil and political rights and freedom, as well as individual equality before the law. In the ground of international human rights law and obligation, UNIAIDS suggests countries to adopt human right-based approach in responding to the pandemic of COVID-19. With the past event of reducing the impact of HIV, the UNIAIDS Executive Director, Vinnie Byanyima, mentioned that successful responses to global epidemic are always grounded in the respect for human rights and community leadership. He also mentioned that to come through the global epidemic, we must ground the response in human rights, engage communities, and leave no one behind. Human rights-based approach should be employed as it is crucial to public health emergency, as they range from tackling stigma and discrimination faced by affected individuals, establishing trust between communities and public health authorities, and protecting critical frontline medical workers. However, with the new guidance to reopen the US economy, which unveiled by President Donald Trump, the US could see 3,000 daily deaths. As human rights are fundamental to the American, the data clearly shows that reopen of the economy and lockdowns causes more cases and death. This indicates that the right-based approach is currently not working, and it is not the right time to fight for human rights.
In conclusion, based on the discussion and reasoning laid out previously by my friends and I, it is submitted that green light theory is the appropriate theory to be applied as opposed to red light or the right-based theory, in light of current events in 2020, particularly the situation regarding the outbreak of the COVID-19 pandemic. That is all from us. Thank you and have a nice day.